Good morning or good afternoon, depending on where you may be joining us today. Thank you for attending today's presentation, Leap into Compliance 2024 Employment Law Updates. Although this webinar is hosted by Cisive, a global provider of compliance-driven human capital and risk management solutions, some of you may be joining us from one of our family of brands. Whether you signed up through PreCheck, DriverIQ, or our other divisions, thank you for joining us. Before we get started, I wanted to review a few housekeeping items. Due to the high volume of attendees, everyone will be muted to ensure the best experience. If you experience any issues during the presentation, you can interact with us using the chat pane in Zoom. This presentation is being recorded and we'll share the recording after the webinar with everyone who registered. If you have any questions for the presenters, you may enter them in the Q&A tab and we will try to address them at the end of the presentation. Today's webinar has been pre-approved by both HRCI and SHRM for 1 hour of continuing education unit. We will email the credit information once the webinar recording is available after today's presentation. Also, please keep in mind this presentation is intended for informational purposes only. Neither this presentation nor the materials presented during the webinar should be construed as legal advice. Thanks again for joining us today. Without further ado, I'm excited to introduce our speakers, Megan Mitchell and Kevin Coy from Arnall Golden Gregory. Megan and Kevin, please take it away.
Thanks, Antique. Thank you, everyone, for joining us today. My name is Kevin Coy. I'm a partner in Arnall Golden Gregory's Washington, D.C. office and co-chair of our privacy and cybersecurity practice. So I advise a wide range of clients on background screening and other privacy issues, both U.S. and international. And I'm excited to be here today with my partner, Megan Mitchell. Megan, let me flip it over to you to introduce yourself and to kick us off.
Great. Thanks, Kevin. Thanks, Antique. My name's Megan Mitchell. I'm a partner in AGG's Atlanta office, and I'm a co-chair of our litigation group and also a co-chair of our background screening industry team. I do a lot of work in general litigation, but also employment litigation and employment counseling and background screening matters. So we're excited to be with you today. Thanks for tuning in, and thanks to Cisive for hosting us. So with that, we will kick it off into the content. Antique, if we could get the next slide. So today's webinar is going to discuss employment updates over the last year. And I'm sorry if I could get the slide before that, Antique. Thanks. So I just want to set an agenda for us really quick. We're going to talk about some employment updates and really kind of from our view or my view as an employment lawyer, sort of the major things to keep in mind, major developments that have happened over the past year. We'll focus on a couple of specific topics and then cover a few more additional updates that have happened. These are also things that we think there's going to be more movement on in 2024, leading up to the presidential election. So we'll give as much of a forecast as we can, knowing that there's a lot that's going to change this year. And then Kevin's going to talk about background screening and privacy updates as well. So jumping into the first major development that we want to cover today, it comes from the Department of Labor, and it relates to independent contractor classifications. And for those of you who may not be aware, the Department of Labor is responsible for enforcing a lot of the major federal employment laws that apply both to nonprofits and to private and public employers above a certain size. So this announcement of a new independent contractor rule is something that we had all been paying attention to for a long time. And we think we know what the test is going to be, although it tends to change and may change in the future. But Antique, if we can go to the next slide. So I put new independent contractor rule in quotations because it is a return to a lot of concepts that we had seen in the past. So this new rule was published just last month, and it's scheduled to go into effect on March 11th, a couple of weeks from now. The new rule reverses a rule that had been in place since 2021, and it's really a return to what we call the economic reality test that existed prior to 2021. And when it published the rule, the DOL said that the goal of this new/old independent contractor test is to decide if a worker is economically dependent on the employer for work or is instead in business for themselves. So compared to the rule that was in place in 2021, which I'll talk about in a minute, this interpretation of the test from the DOL tends to make it more likely that a worker is going to be considered an employee rather than an independent contractor. Antique, next slide. So you might be asking yourself, why does this matter? And it matters because independent contractors are generally not subject to all of the same laws and regulations that apply to a business's employees. And there's a laundry list of those laws. I've listed just a few of them here, but they include the Fair Labor Standards Act, which governs wage payment, Title VII of the Civil Rights Act, which is an anti-discrimination law. Now, independent contractors do have some protections, including with respect to racial discrimination, but they don't enjoy the host of protections under Title VII that apply to regular employees. These are things like age discrimination, gender discrimination, any of those protected classes that apply to employees. Independent contractors also aren't subject to the Age Discrimination and Employment Act, the Americans with Disabilities Act, OSHA Act. They are also not entitled to leave provisions that are available under the Family and Medical Leave Act. They're also not subject to employee benefits laws that are set forth in ERISA. So there are a lot of primarily cost savings or administrative benefits to classifying a worker as an independent contractor rather than an employee. But if a business gets it wrong, misclassification of a worker as an independent contractor instead of an employee can cause an employer to face a lot of monetary consequences. That can include paying back pay, paying minimum wage, and other wage obligations that employees receive, overtime, benefits, health plan coverage. A lot of different things that employees receive, you might have to pay to an independent contractor if they are misclassified. And if you have a lot of independent contractors on staff, this can become a pretty big headache. And as we'll discuss in a minute, the test is not necessarily easy. So next slide. So let's look at the new rule. The new rule applies the economic realities test under a totality of the circumstances approach, which means that no one factor is going to be dispositive. The DOL or a court would be supposed to look at all of these factors holistically. So the factors are the worker's opportunity for profit or loss, depending on managerial skill, investments by the worker and the employer in the business, the permanence of the work relationship, the nature and degree of control, whether the work performed is integral to the employer's business, and skill and initiative. And I'll go through these factors in a moment. The 2021 rule that was in place, only for a short period of time, it actually gave greater weight to just two factors: degree of control and opportunity for profit or loss. So under the old rule, if those two, what were considered core factors, supported the same classification, then there was a substantial likelihood that the classification was appropriate. So for a few years, some employers and some courts in the DOL focused more narrowly on a couple of factors. Now there's a wider host of factors that will come into play in the classification analysis. Next slide. So under the new rule, I want to walk through the 6 factors a little bit to help clarify and give some examples of how difficult it may be in some cases, or maybe there are misconceptions about who is an employee versus who is an independent contractor. So opportunity for profit or loss, depending on managerial skill. What does that mean? The relevant factors that the DOL has identified include whether this worker negotiates their pay, for example. Do you have a discussion with this person about how they're going to be paid, and is there a back and forth? Do you get a price schedule or something like that from this worker? Do they decide to accept or decline work that the business provides? Do they hire their own workers? Do they purchase their own material and equipment, office supplies, things like that? Do they have any marketing efforts? Do they advertise? Do they have a separate business? Are you retaining someone via an LLC, or are you retaining someone in their individual names? That's something that the DOL looks at under the new test. Investments by the worker and the employer is another piece of the analysis. So this looks at whether a worker makes investments in the business that are capital or entrepreneurial. I mentioned this earlier, because some of these factors do overlap to some extent. But is this a person who purchased their own software, is using their own computer? Are they renting their own office space and providing and doing work from a separate location from where the business might be located? Those are all things that would tend to favor an independent contractor classification as opposed to an employee classification. The DOL is also going to look at the permanence of the work relationship, which relates to the nature and the length of the work. So is this a person who takes on a lot of different projects with a lot of different companies, and those projects maybe have a defined end time? They take 6 weeks, they take 2 months, and then this person moves on to another project for another company. Or is this a person who is working with a single company for a very long period of time? That may favor an employee classification as opposed to an independent contractor classification. Next slide. The nature and degree of control is the fourth factor. This looks at the level of control that the potential employer has over the individual's performance of work and economic aspects of the working relationship. And this is something that a lot of state courts are going to look at, a lot of different tests that may apply in other jurisdictions, which I'll mention in a moment. Nature and degree of control has always been a core part of the independent contractor test. So does this individual have the ability to determine their own work hours and their place of work? Are there metrics or some sort of standards or rules that apply to how this person performs the work that they're doing? How are they paid? How frequently they're paid? How much negotiation there is over pay? Who supervises the work, and how does that supervisory structure work? These are all questions that a court or the DOL would ask to help determine whether someone is properly classified as an employee or an independent contractor, with the more control being asserted by the business, making it typically more likely that the person should be classified as an employee as opposed to an independent contractor. This fifth factor, whether the work performed is integral to the employer's business, this is something that the DOL provided a little more guidance on in its rule that came out in January. So the DOL is describing here whether the work is critical, necessary, or central to the potential employer's principal business. An independent contractor is someone who is more likely to work on projects that are not integral to the business, which might be a little bit opposite from what some folks would think. But the DOL is indicating that if projects that are central and necessary and critical to the type of business that you run are being worked on by workers who are classified as independent contractors, that will raise a question in their minds about whether that person is properly classified. So independent contractors in the DOL's view are individuals who are more likely to work on things that are not part of the business's day-to-day operations and bread and butter, things that are more one-off side projects. And then finally, skill and initiative is the sixth factor in the 2024 test. So this factor is similar in a lot of ways to the first couple of factors that we discussed. This looks at whether the worker is someone who uses specialized skills and business planning and effort to support support growing a business or perform the work that they do. So this might be someone who does graphic design, for example, and has very specialized artistic skills and is able to use artistic software, just as an example. And they advertise those skills and market those skills and have their own business and work with a lot of different clients. That's an example of someone who would demonstrate the skill and initiative that might indicate a proper independent contractor status as opposed to an employee status. And there's a link in the slides at the bottom. All of this guidance comes from a fact sheet that the DOL issued in connection with the rule. It's really helpful. I'd encourage you to check it out. It gives you a lot of examples and more specific discussion of how the DOL intends to apply this test to employee versus independent contractor classification. Next slide. So now that we've discussed what the rule actually is, do you have to follow it? There's a lot of question about that, actually. So this happens really every time the DOL issues a major rule. There are legal challenges that have already been filed in federal courts, and there's a specific challenge to the DOL's ability to rescind the 2021 rule in the first place. So we will see how those play out, but the applicability of the rule is not stayed at this point. One thing to note is that federal courts are not required to defer to the DOL's guidance on independent contractor classification, but they often do. So if the DOL comes to your workplace, that's one thing. If an employee sues your business saying that I was misclassified as an independent contractor when I was actually an employee and I should have been paid these amounts and I should have received these benefits, then the federal court may use a test of its own. It may consider other factors. It may look to state law. So this is something that's really tricky to navigate for employers. And the interpretation may change with a new presidential administration. So if we have an administration change at the end of the year after elections, this is something that these rules from federal agencies tend to have political associations, and they may differ depending on what political party is in power. So that is something that could change in the future as well. So I mentioned earlier that some states have different standards for employee classification. A lot of states use what's called the ABC test. So I wanted to mention that just so that it would ring a bell if you're in one of these states. ABC stands for absence of control, the business of the potential employer, and customarily engaged in the type of business. And what that really means is that courts are going to look at whether the employer controls this person's performance of the work, whether it relates primarily to the business of the employer, and whether this is a type of work that the individual is customarily engaged in for other businesses and other potential employers. Meaning, I'm a person who does graphic design for a bunch of different businesses. I do party planning and event management for a lot of different organizations, and the fact that I did that at this organization for 6 weeks doesn't mean that I am actually an employee. It means that I'm an independent contractor. But we're seeing the trend right now favor a more employee-friendly classification. And so the trend now is that the rules are going to tend to be construed in favor of employee status and employee benefits as opposed to independent contractor status. And in June of last year, we saw another example of this when the National Labor Relations Board, which deals with union workplaces, it also reversed its independent contractor standard to align with what the DOL then proposed earlier this year. So it returned to a standard that favored this review of a lot of different factors and a holistic approach to determine whether someone is an employee versus an independent contractor. And it favors employee status. And that's important because, as we'll discuss in a moment, independent contractors would typically not receive protection under the National Labor Relations Act. And there has been a lot of movement in that space. So we'll turn to that topic next. Next slide. So another big trend in 2023 that we think is going to continue into 2024 is increased activity from the National Labor Relations Board. Next slide. The National Labor Relations Board issues rulings and opinions related to interpretation of the NLRA, which I'll discuss in a second. But as context for this, anyone who follows the news probably noticed an uptick in union activity in 2023. And really, this is a trend that started to tick up around the time of the pandemic starting. So there was a strike in Hollywood. There were a lot of actions at different workplaces that traditionally had union activity. But something that started to happen more frequently was activity towards collective bargaining or unionization in workplaces that typically had not seen a large union population. So the map here on the left shows locations and volume of work stoppages or labor disputes in 2023. And you can see that it's pretty spread out across the United States, regardless of political affiliation. The chart on the right also shows days of work lost due to labor disputes since 1981. So you can see the huge uptick last year as compared to prior years in terms of days lost. So big impact on the economy and a big impact on employers who are navigating how to deal with union activity that they might not be used to dealing with before. So next slide. So the National Labor Relations Act is a law that applies to almost every employer, like other employment-related laws. But a lot of employers don't think that the NLRA applies because they don't actually have a union operating in their workforce. That's not true. And so we'll discuss a few ways that employers might become subject to provisions in the NLRA that they may not be otherwise familiar with. So the two primary sections that I'll focus on are Section 7 and Section 8. These two sections basically guarantee employees the ability to talk with each other, to bargain with employers, to seek mutual aid or protection, and they prohibit employers from engaging in what are called unfair labor practices, which would interfere with employees' rights to discuss the terms and conditions of their employment and to join together to bargain collectively about terms of employment. Next slide. So the most recent development relates to the NLRB's new joint employer rule, which this is a rule that helps the NLRB determine whether an entity is subject to its requirements. And so this rule has several factors shown. I know there's a lot of text on the screen, but under the NLRB's new rule, two or more entities will be considered joint employers of a group of employees, meaning that they have to engage in all of the NLRA's requirements. If they have an employment relationship with the employees, and if they share or co-determine at least one of the following essential terms and conditions of employment. So what are those terms and conditions of employment? They're things like wage payments, benefits, hours of work, scheduling, assigning duties and supervising those duties. So think about in a staffing context, there may be folks who are on a work site who are not at all employed by the primary business there, but the primary business is determining those folks' hours of work, the policies that apply to those folks. They're supervising their work. They're involved in hiring and firing, for example. These are all factors that the NLRB would consider. And importantly, all of these factors are going to be considered in terms of the potential second entity's ability to control these so-called essential terms and conditions of employment, regardless of whether the control is exercised directly, indirectly, or at all. Meaning that if there is any contract or agreement or policy that gives that second entity the ability to control these terms and conditions, even if it's never used, that might dictate a finding that the second entity is a joint employer of the same individuals. So this rule is also going to go into effect on March 11th. And the NLRB's intent in issuing this new rule is to broaden the universe of potential employers subject to the NLRA's requirements. Next slide. The NLRB is also taking a particular look at specific types of agreements that a lot of employers enter into with their employees. So the example on the screen is text from a separation agreement, a severance agreement that a hospital gave to some of its employees when they departed. These are commonly used when an employer is providing benefits to an employee as part of a termination. The employer asks the employee to sign a release of certain claims in exchange for receiving those payments. So this agreement contained a confidentiality provision and a non-disclosure provision. So under the confidentiality agreement, it basically means that this employee is not allowed to talk about the terms of this agreement under which they received payment with anyone other than a spouse, a legal advisor, or a tax advisor. It also contained a provision regarding non-disclosure, which is similar to the confidentiality provision, but it also has this second sentence that says the employee agrees not to make statements to employers, other employees, or to the general public that could disparage or harm the image of the employer or its affiliated entities or employees. So both of these provisions are fairly common in these types of agreements. But the NLRB took issue with both of them and found that both of these provisions violated sections 7 and 8 of the NLRA, with the reasoning being that these provisions would prevent an employee from talking to other employees about the fact that they had received a severance payment, the amount, and that the non-disclosure and non-disparagement provision could potentially prevent these employees from discussing terms and conditions of their employment in furtherance of collective bargaining efforts. So this was an important development for many employers. Next slide. So the NLRB also has looked at employment agreements, which are sometimes used depending on the employee at issue. And some of the common terms in employment agreements, or common terms that might appear even in an offer letter or some sort of other communication, such as a confidentiality agreement with an employee, and has provided additional guidance on whether it thinks that these types of common provisions would violate the law. So a 1-year non-compete provision, which is commonly included in a lot of employment agreements, the NLRB found that it didn't violate the act if it allowed the employee to access other employment opportunities. Likewise, a confidentiality provision in an employment agreement could be lawful if it's narrowly tailored to focus on trade secrets and proprietary information. things that don't chill the employees' exercise of their ability to talk about the workplace in a way that doesn't reveal confidential, non-public information. But a provision that prevented an employee from engaging in activity competitive with or adverse to the employer's business or welfare, which is also a fairly common term, was unlawfully overbroad because an employee who's economically dependent on the company could read such a provision to preclude them from attempting to organize a union or engaging in other protected concerted activity just because the employer deemed that activity to be adverse to its business. Next slide. So the takeaway here is that, number one, remember that the National Labor Relations Act applies to both unionized and non-unionized workplaces. And it's important to think about, in any communications or agreements that you may enter into with employees, to be careful with non-disparagement and non-disclosure clauses that may limit the exercise of speech or engaging in collective bargaining efforts. One way to deal with that is to narrow terms to financial information only. The same is true for confidentiality provisions, focus only on proprietary or trade secret information. But as a whole, it's important for businesses to think about any terms in any employment-related agreements from the perspective of the employee's right to engage with one another with respect to the terms and conditions of employment. And this follows a trend that we saw over the past year and that we think will continue towards favoring employee rights, favoring employees' ability to be employees in the first place, right? So with the change to the independent contractor rule, and also to work together to improve the workplace. So we think we're going to see continued NLRB activity moving forward. Next slide. So in a couple of more minutes, I want to just really quickly hit a few more employment-related developments. Next slide. So we also saw some guidance from the EEOC this year on a hot topic of artificial intelligence. Everyone has heard about AI and is following developments in the AI space. That's also happening in the world of hiring. So we're seeing employers using tools to help identify candidates or identify suitable candidates. And the EEOC has come out with a technical assistance document that addresses potential violations of employment laws related to the use of AI tools. So it's helpful to know that that's there. And if you're using AI tools in the workplace, this is certainly something to check out. In October, the EEOC also published a notice related to definitions of harassment in the workplace. So this can relate to harassment on the basis of any of the protected classes. And this document it's a helpful read into the mind of the EEOC when it comes to harassment claims, and it has a lot of examples of particular scenarios that are interesting related to, for example, harassment on the basis of gender identity, and it gives a lot of good insight on how the EEOC views harassment. We find that a lot of folks have misconceptions about what constitutes a hostile work environment, for example. And so this guidance gives some more indication of what the EEOC thinks. We also saw activity from the Supreme Court in the employment space this year. So one opinion that is impacting a lot of employers relates to religious accommodation requests. So there's a longstanding body of law relating to how employers are required to handle requests for reasonable accommodations, for religious accommodations from employees. And in this opinion, the Supreme Court held that the employer must show that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. This is a higher standard than the past standard, which was effectively any de minimis burden on the business could justify a denial of a religious accommodation request. So that's something to follow and be aware of if those laws apply to your workplace. And then finally, we also saw, sorry, Antique, if you can just go back to the previous slide, that the Supreme Court struck down universities' race-conscious admissions programs in the summer of 2023. So those types of affirmative action programs were effectively ended by the Supreme Court's decision. That decision doesn't directly affect private employers, but it does have some potential impacts on employers, particularly those who have diversity, equity, and inclusion programs. So that's something that a lot of employers are monitoring as well. So with that, I will turn it over to Kevin to address updates in background screening and privacy.
Thank you, Megan. Thanks everyone for joining us today. If we go to the next slide, please, Antique. For my part of the presentation, we're going to talk about a couple of different areas. First, Fair Credit Reporting Act related developments and CFPB activity in that area in particular. Then we're also going to talk a little bit about state privacy laws, fair chance and ban the box regulations, and salary history inquiries. There's a lot of activity in these different areas to varying degrees. So we'll touch on developments from 2023, and as Megan has been doing, what we're looking forward to in terms of potential 2024 activity and beyond. In terms of the Fair Credit Reporting Act, from an employment perspective, the first thing to say is that Fair Credit Reporting Act litigation is an ongoing issue, particularly for employers. The Fair Credit Reporting Act has a private right of action and also facilitates class action claims. And so employers have been sued increasingly in recent years for areas where they may not be complying with Fair Credit Reporting Act requirements. Those include things like the requirement, if you're obtaining a consumer report for employment purposes, you need to provide a disclosure to the individual as well as obtain their authorization to obtain the consumer report. Those disclosures and authorizations have been subject to a lot of litigation in recent years. And so it's something, if you haven't looked at your forms there recently to make sure that they line up with what the current trends in case law there are, something you should consider reviewing with your legal counsel. In addition, employers also have obligations if, when you get a consumer report, there's adverse information in that report which may lead you to take an adverse action against the applicant, not hiring them, for example, or revoking a conditional offer, or changing their compensation or their hours or other adverse actions like that. You have an obligation under the FCRA to provide the individual with a copy of that report before you take action on it, and also provide them with a copy of the summary of rights that they have under the Fair Credit Reporting Act that's been issued by the Consumer Financial Protection Bureau. The CFPB updated that FCRA summary of rights last year, primarily to update contact information for the various federal agencies that enforce the FCRA in different industry sectors. To make it a little more complicated, they also had to issue a technical correction to that revised notice in August, and where they corrected a couple of errors in the earlier version. But the long story short, there's now a new summary of rights which use is required by March 20th, so just a few weeks away. If you haven't already implemented the new notice, you'll want to look to put that in place in your processes. I understand from Cisive that they're in the process or have been updating it where they might be providing adverse action, pre-adverse action notices on their customers' behalf. But to the extent that you're not doing that through Cisive, or you have questions, or you're providing that manually through other processes, you want to make sure that you've updated your summary of rights so that you're giving applicants or employees that are entitled to it the most recent version of that document. That's one thing that the CFPB has done from an FCRA standpoint recently. They also have been undertaking other activity, really part of a more concerted effort to look at the Fair Credit Reporting Act, not only with respect to employment background screening, but other activities regulated under the FCRA, as part of a look at that they're taking at the information industry more broadly, including so-called data brokers that sell personal information for various purposes. Just in January of this year, for example, they issued an advisory opinion on Fair Credit Reporting Act issues. Most of that advisory opinion focused on the activities of the consumer reporting agencies. So it doesn't include direct requirements for employers or other end users of consumer reports in it, but it still references and focuses on issues that indirectly affect employers, like the content and the formatting of reports, how the Fair Credit Reporting Act rules for how long you can include adverse information in a report are to be interpreted, which will potentially shape how the reports are formatted and what information goes into the reports. So it's something to keep an eye on. That is an advisory opinion. They're also in the process of revising the regulations for the Fair Credit Reporting Act. They took over responsibility for those regulations back in 2011 when they were formed, but they are now considering potentially significant revisions. They've put it on their agenda. They expect to issue an advance notice of proposed rulemaking this year. So they're still at the relatively early phases of the process, but they will potentially be making significant changes. Again, many of these are focused primarily on the consumer reporting agencies, the background screening companies, but some of those changes will have potentially important implications for employers and other end users, because the CFPB is focusing on what constitutes a consumer report, what information may go into a consumer report, what types of information can be used for what purposes, as well as requirements around what constitutes written authorization from a Fair Credit Reporting Act standpoint. It's not clear that they will address what constitutes a proper authorization from an employment purpose under FCRA, but they are talking about setting out parameters for written instructions. And so if you are obtaining consumer reports pursuant to written instructions, there may be new rules for you there forthcoming as well. The CFPB just yesterday, as part of another initiative, reaffirmed their intention to issue those regulations, at least in proposed form, in the next few months, and they intend to try and advance that effort over the course of this year. So that'll be something to keep an eye on, because it may have some direct impacts on employers, also potential indirect effects to the extent that it's affecting how consumer reporting agencies are able to prepare their reports and provide them to employers. The other thing just to say about the CFPB from a Supreme Court perspective, two things. One, they're currently being challenged in the Supreme Court over the constitutionality of their funding structure. Today, they're funded indirectly through the Federal Reserve in a way that's not the typical appropriations process that most other agencies go through. And a Court of Appeals, the Fifth Circuit, found that to be unconstitutional. The Supreme Court heard that case recently, and they're expected to issue a decision by the end of June. The outcome there, not entirely clear. Also not clear what would happen if the Supreme Court found the funding mechanism to be unconstitutional. There's those that would like to argue that would render the entire agency unconstitutional and sort of do away with everything that they've done in the past dozen or so years. That seems like an unlikely outcome, but we'll have to see what the court actually says there. There are also some other cases, not specifically involving the CFPB, which could affect what sort of deference the federal courts give to this FCRA rulemaking we're talking about, or other rulemakings like the ones that Megan was discussing earlier. But that's also an issue for another day. If we could go to the next slide, please, Antique. Now, state privacy laws. This is very much a moving target. We currently have 13 states that have adopted sort of a new generation of what's sometimes called a comprehensive privacy law, because it applies to businesses across industry sectors and provides consumers with a number of rights with respect to their data. New Hampshire may soon be joining that list, taking us up to 14. And then there are a couple of other states, including Washington and Nevada, which have adopted broad health privacy laws that focus on how health information is handled. And at least 19 other states have these types of privacy bills pending this year. We expect that several more will probably make it across the finish line this year. And I just wanted to give a shout out here to Nebraska. There was a pre-question about activity in Nebraska. Nebraska is one of the states that's considering privacy legislation as well, although it hasn't gotten across the finish line yet. For our purposes today, the key question with respect to those statutes is, generally speaking, how do they impact the employment situation? And the answer is that most of them exempt in one form or fashion employee-related information or interactions from their coverage. They're written with consumer sentiments and interactions as their primary focus. So more on the business side of the house than the HR side of the house. The prominent exception to that is California. The California Consumer Privacy Act now expressly applies to employee data. And so if you have employees in California, and if you meet the triggers for applicability for the CCPA, which are if your organization has total revenue of more than $25 million a year, or you're collecting personal information about 100,000 or more consumers, meaning California residents, over the course of a year, or more than half of your revenue comes from the sale or sharing of personal information, then you're covered by the California law unless some other exception applies. For example, nonprofits are excluded from coverage under CCPA, and I saw that we've got a potentially number of nonprofit organizations joining the webinar today. But if you're covered by CCPA, then it applies to your processing of information about employees as well as and applicants and former employees as well, not only your interactions on the business side of the house. And so as a result, you would need to have a privacy notice that complies with California requirements. You'd also need to have operational controls in place that meet the various California requirements. California is in the process of revising and expanding its rulemaking in this area. Last year, the California Privacy Protection Agency finalized new revised regulations that took effect last March. And they're now working on additional regulations to focus on other areas that they didn't cover in the initial regulations. There was litigation ongoing about when enforcement on that could begin. The California Chamber of Commerce was initially successful in the lower court getting that put off. They argued that there should be more time before enforcement could occur. But earlier this month, the California Court of Appeals held that the agency should have been able to begin enforcement last July. The Chamber of Commerce has now appealed that to the California Supreme Court, and we're waiting to hear whether the Supreme Court's going to hear that case. And as I mentioned, the court's also going to be looking at additional regulations about cybersecurity, audits, risk assessments, and automated decision-making. they have a meeting next week where they're going to consider whether they're going to be moving those forward. And so if you are covered by a CCPA, certainly activity to continue to monitor in California and to continue to build out your privacy program, not only on the business side of the house, but with respect to employee data. Next slide, please, Antique. That brings us to fair chance and ban the box laws. And these have been around in one form or fashion for a number of years. They do a variety of things from ban the box was a shorthand for the traditional employment question that for many years was on employment applications, asking whether an individual had been convicted of a crime or had other types of criminal history related events. And those early laws were intended to take those questions off of the applications. That's broadened over the years into what's being referred to as often as fair chance laws, which are a more extensive set of rules around how criminal history information, conviction information in particular, can be used during the employment process. California, again, an active player in this space, although many states have these. Some of them only apply to the public sector. Others apply to the private sector. They also are not only at the state level, but also at sometimes the county or municipal level. And so you'll need to keep an eye on all the locations where you're doing business to consider whether your jurisdictions have these laws and whether they're applicable to your operations. California, as I say, issued revised regulations that took effect October 1st. So there was already a version of these regulations in place, but California expanded the scope of those regulations, reaching some additional labor and staffing situations. They also broadened the definitions of applicant and employer so that they apply a little more broadly there with respect to applying to current employees, for example, not only applicants. So if someone is applying for a new position or a new role, this is potentially applicable there, not just to new hires. The process is set up to require that the conditional offer be made before criminal history can be inquired into, considered, distributed, or disseminated. So a fairly broad prohibition on being able to look at criminal history until the conditional offer has been made. And then prior to revoking a conditional offer based in whole or in part on criminal history information, it's required to conduct an individualized assessment, taking into account specific factors, including the nature and the gravity of the offense, the time that's passed since the offense or conduct occurred, or the completion of the sentence, the nature of the job held or being sought. Those factors were in the earlier regs and track longer term case law about what can be considered with respect to criminal history information. What the regs do is expand that to also cover more sub-factors that as you look at each of those three areas, you need to take into account when evaluating the information that you receive. And also, if someone has voluntarily provided evidence of rehabilitation at this stage in the process, then that has to be taken into account as well. Next slide, please, Antique. Now, if you've taken the rules, if you've gone through that process and you think you're not going to revoke the conditional offer that you've made, then you have some additional requirements to go through under the regs. First, you need to provide the individual with notice of that preliminary determination, along with information about the criminal history information involved and the process, so that they then have the opportunity to challenge the accuracy of the criminal history that's the basis for the preliminary decision, and or to provide evidence of rehabilitation or mitigating circumstances. And the revised regulations expand the list of what may constitute rehabilitation or mitigating circumstances. That's one of the changes the new regs have, as well as the types of documentary evidence that may be provided by individuals in support of their their mitigating circumstances. The regs also expressly prohibit employers from requiring any particular type of evidence, such as a police report, or requiring the submission of any information at this point in the hiring process. Also prohibits employers from refusing to accept additional information. Essentially, the focus here is that this is a voluntary option for the applicant to try and provide evidence to indicate that the preliminary decision shouldn't be taken to final, but they're not required to do so. The regs also require that applicants have to be given at least 5 business days from the date of receipt of the notice to respond, which raises sort of the question of, well, how do I know when they received it from a calculation standpoint? And the regulations go into some detail about that, depending on how you conveyed the message, whether it was something that could be where delivery receipt could be confirmed. If not, there's some baseline assumptions depending on how you send it as to when that's calculated, but you do have to give them at least 5 business days to consider it. And then if you choose to rescind the offer based in whole or in part of that information, written notice is required, and you have to provide some additional specific content called out by the regulations. Next slide, please, Antique. We also seen fair chance and ban the box activity, both direct and indirect, in other jurisdictions as well, just to illustrate that this is a multi-state and multi-jurisdiction issue to keep an eye on. Texas was indirectly going in the opposite direction. They had a bill enacted last year, the Texas Regulatory Consistency Act, sometimes referred to as by critics as the Death Star bill, because it was intended to, from the state level, preempt many local labor laws. Among them would be Austin's Fair Chance Ordinance, and that was scheduled to take effect September 1st last year. A district court in Austin enjoined enforcement just before it was scheduled to take effect. Texas Attorney General is appealing that decision, but that process is still ongoing, and the new law is currently on hold while that litigation continues. But that's an example of a situation where a state may preempt a local fair chance ordinance if that's reinstated. Philadelphia, another example, just to say there that they had some changes take effect January 19th. They've frequently amended their law, so it's just an indicator to keep an eye on these laws because they can change frequently. Philadelphia tweaked theirs to prohibit consideration of convictions when there's been something that subsequently constitutes what the law calls exoneration, so that if there's been a pardon or a dismissal or some other post-conviction reexamination that effectively reverses that decision, then it can no longer be considered for employment purposes. Next slide, please. Salary history inquiries. These laws, again, in many states, some applying to public entities only, some also to private, restrict the ability of employers to ask about salary history or use it for benefits purposes. Minnesota has a new law that took effect on January 1st, and you see a few bullets here on the screen about what it does from a processing standpoint, prohibiting employers from asking about or requiring disclosure from any source, the pay history of an applicant, as well as a few other factors. The Minnesota Department of Human Rights has said this law applies to all applicants, including current employees seeking an internal promotion or transfer. So if you're in Minnesota, some new requirements there to take a look at. Next slide, please. Columbus, an example of a municipality that has a salary type of restriction. The new Columbus requirements are going to take effect on March 15th, so just a couple of weeks away. Unless an exception applies, an employer with 15 or more employees is prohibited, unless an exception applies, from inquiring into the salary history of the applicant or screening applicants based on their prior wages or benefits. Note that this one is focused on employees within the city of Columbus, and you need to have 15 or more of them to apply. So for this to apply, but if that's the case, you'd have some additional obligations here. You're also prohibited from refusing to hire or otherwise disfavor an applicant for not disclosing their salary history information. As I said, there are some exceptions here, including for certain rehires, among others. So if you're in Columbus, something to take a look at there. Next slide, please. That brings us to our 2024 forecast. Next slide, please. From a privacy perspective, and I'll bring Megan back in here to add anything she has in closing on employment. I've covered sort of the forward-looking piece of most of the privacy content. Just to add that from an electoral standpoint, with elections this year, as you said, I didn't say much about federal legislation from a privacy perspective because none's really expected. Congress has been struggling with privacy legislation on the Hill for a long time. While there's always the possibility of surprise, nothing's really expected. We expect most of the activity to continue to be at the state level. Megan?
Yep, I think we've covered it in terms of keep your eye on the election. Things are likely to change, but we expect to see some increased activity leading up to the election. So that's something that we're monitoring and that you should monitor as well. Employment law is always changing. So use your sources, and we appreciate you tuning in. Thanks to Cisive for having us.
All right, thank you for joining us today, Kevin and Megan. I'd like to thank you for being with us and providing us with such an informative and timely presentation. As a reminder, we will share the webinar continuing education credit information as well as the recording via email in the coming days. Thanks again for joining us and have a great rest of your day, everyone.